that make it worse?
They essentially just said that both tribes are working on standards and sort of disregarded every.
Overlook the fact that you have them in place and they're approved.
Yeah.
Oh shit.
It's weird.
That is weird.
They just sort of generalized it more.
I'm sure you guys won't. I won't need to do this. But if I do, I'm going to introduce everyone all at once, and then I'm just going to sit there because I think it's easier and less awkward.
You'll need
than,
to
like,
cue me. I
sneaking
can
up on
talk
you.
forever. So.
Okay. And you have about 15 minutes. So I will, if you want me to cue you, I will. And just look for me right there in that row.
Good.
So, she's there.
Same name.
How you doing?
Good. Nice to meet you.
Nice to meet you. Scott.
Scott? Yes, how you doing? Good. I think I met you once, didn't I?
It's possible.
Yeah. Right here? Yeah.
Tommy, you're still
Tom
okay
Ships
with
couldn't
going
make it down, or?
Couldn't.
I'm always last.
You're
Death
Oh, I'm sorry.
Did you
It's kind of
He's in
but I had to think of some more.
but he wasn't trying to do it very well.
That's tough.
So Tom, I'm gonna introduce everyone just all at once.
We were down in Southern Butte.
Because I think it's, if I have to give you the prompt, it's just less awkward
Our
than
office.
standing up.
Do you
and
remember
doing
there's a
my
guy
thing.
come down?
So just look for me in my front row. Not that they'll need it. Just
Yeah. Well, I might. I worked with a senior tribe then. He was an attorney way back then. Put that out. And so helped some of the first, that year we processed, helped the agency process 400 permits for open methane. It was a tax credit that expired at the end of the year, so we had to get it out early. And so, yeah, we got to go there. Actually, we funded a lot of studies up in there up until, Naranjo came on in what? Mid-80s, mid-90s, in there, and then, yeah, we
Mr.
funded
Fredericks?
programs
Hi, Scott Clove. Nice to
you
meet you.
guys until about
Scott Clove.
oh, okay. Early 2000s.
Been a long time since I've been to you. Or Southern Ute or Utah?
Again,
Okay.
things have really slowed
Yeah, I
down.
negotiated
Actually,
with Dolores water pretty good.
Oh yeah.
It's a real problem.
Water Right Settlement
Yes,
Act.
Not the settlement act, but before that,
So we haven't
when
done
Dolores was authorized,
I was actually shocked that you could see
we put it on, it's salt water.
Sure. And so we're gonna ask you to help
We
out.
put it in that bill, I negotiated it when I was at Naranjo. A guy by the name of John Wayne was on the council.
Expedite the process, because what's happening is that you guys are in the year 2015 as far as climate technology and everything else, and the agencies in the 1970s. So our job is to bring them up, train people, and get programs like Naranjo installed there. Try to have the agency, so that now they're sharing the same data.
Oh, that'd be great.
Yeah, that's what we're doing right now. So yeah,
Nitrogen?
National Liquid Oil and Gas Evaluation and Management System. Took a couple beers to figure that one out.
Yeah.
We got it done. Okay.
Yeah, okay, that's terrific.
Yeah. So yeah, we're actually there. So yeah, that happened because you guys were doing great.
Yeah, there's
Us.
no reason for
No,
this kind of
actually,
slowdown.
yeah,
delay.
yeah. Tell me about it.
So Stephen, I just want to mention, I'm going to introduce everyone all at once, and I'll just say your names in the order you're going to speak. Which
Okay.
is Scott, then you, then Sam,
Okay.
and then Tom, and then I'll be sitting right there with that way there is a need to show you the time card.
Okay.
I won't have to stand up and tug at your sleeve, you can just look at me sitting there.
Okay. No cattle prods. Okay.
Absolutely.
Only necessary, but you have it. That's good to have it in reserve.
So I'll go check with Christina.
Okay. Good deal. Thanks.
Well, that's the first I've heard of that.
Uh-huh.
I've been working on trying to get some of the energy transactions processed and very slow process.
Just from a standpoint, the problem is that we went in and took a look at the database that the agents always use, and there's a polite way of saying it. 50.9% of it was right. Okay. So the database they were working with was terrible. Okay. Tribe had a much bigger
And
database.
we are going to start our panel on natural resources in the Ute tribes. These are crucial issues. They always have been, of course, for the Ute people, and the contest over natural resources water, their land, their mineral, and other natural resources in the way that they determine is the right way to use them, will get, I think, increasingly sharp. That contest will get increasingly sharp as we move ahead in the coming decades and face all the issues we know we're facing with respect to drought and the other challenges accompanied by climate change. So this is a really fantastic panel to help us think about these issues. And I'm going to introduce all 4 speakers at once and then sit down. And I'm going to introduce them not in the order in which they're sitting, but in the order in which they're speaking, just to add a little bit to the confusion. But the name tag will help you sort all that out. Did you hear anything I just said? Oh, good. I also want to acknowledge, I know other folks have already today, but I really do want to thank Professor Kristen Carpenter, who did just the lion's share of work to organize this and did it quietly and with grace, as she has done everything around this law school. And we really have her to thank for taking our American Indian law programs to a new level. And I also want to welcome Carla Fredericks. I actually don't know if she's in the room at this second, but she's our new American Indian law colleague here. She'll be teaching our clinic, and that is just very, very exciting. It's terrific for our students. It's going to be great for our presence in Indian country, in the state and throughout the country. And she has a relative on this panel. That's the segue. So here's our panel. Scott Clough has worked for the Ute Mountain Ute Tribe since 1996. He is now their environmental programs director and works on every issue with respect to natural resources and environmental issues on the Ute Mountain Ute Reservation for the tribe. And as always, by the way, the longer bios are there in your book for you to refer to. And Scott is going to be our first speaker. Our second speaker will be Stephen Manydeeds. He's a member of the Standing Rock Sioux tribe, and he is the chief of the Division of Energy and Minerals Development for the Bureau of Indian Affairs. This is a really significant job with a huge geographic reach. It's the entire country's Indian lands that he oversees with respect to energy and mineral development. Our next speaker will be Sam Maines. Sam is a partner at Maines, Bradford, Ships and Sheftel in Durango, Colorado. He is a graduate of this law school. He has done a great deal of very important American Indian law and natural resources law work for the Southern Ute tribe. Among his many projects are assisting the tribe with the development of their air pollution control program. And we're lucky to have Sam both as an alum and here with us on the panel. And then last, but by no means least, the speaker for our panel today is Tom Fredericks, also an alum of Colorado Law. He is a senior partner at Fredericks, Peebles & Morgan. He was a former director of the Native American Rights Fund. Also was the associate solicitor in the Department of the Interior and the assistant secretary for Indian Affairs during the Carter administration. And that only really begins to tell the story of Tom Fredericks' very, very significant involvement in the development of American Indian law in the modern era. He was involved in many of the most important cases, including, of course, natural resources cases, the subject of our panel today. So with that, I will now turn it over to Scott, our first speaker.
Good afternoon. Pleasure to be here. I'm not an attorney, so and I'm not a graduate of CU, so I guess a little fresh air maybe or something. I wanted to touch on 4 specific ways that our environmental programs department works on natural resource issues and our Justice Department on legal issues, and so those are briefly water quality, oil and gas issues, water rights, and I understand there's another whole panel on that, so I won't get into that too much. And then just interacting with federal and state agencies in general on natural resource issues. When I started working for the tribe almost half of my life ago, we didn't interact. Our environmental programs department, it was only 3 people at that time. We didn't really lean on our attorneys a whole heck of a lot then. And it has steadily ramped up to the point where I joke with Celine Hawkins all the time that she creates work for me and I create an equivalent amount of work for her, because we're always working together on these issues, because more and more it seems like whenever we get into a natural resource issue, it turns into something that needs some legal opinion and support. So we work really closely with Peter and Celine and the Justice Department. So on the issue of water quality, we, in the late 1990s, started looking at regulating surface water quality. And the Clean Water Act was amended in the 1980s to allow tribes to be able to do that in the same manner that states do, to get a delegated program, what they call TAS, treatment in the same manner as a state. This is something that with environmental laws we see a lot of. They write an environmental law, especially the Clean Water Act, and some of them from the 1970s, and a decade or two goes by and they go, oh, what about Indian country? And so they did that with the Clean Water Act, and in the late 1980s they created a section that allows tribes to regulate water quality, the same as states. And so we were interested in going down that road, and in the late 90s started to talk to the tribal council about it. And in 2000 we did two things on that. We actually adopted tribal water quality standards, and these were mostly technical standards. They didn't really have an implementation procedure in there. But the tribe adopted them and said, yes, well, you know, let's try to see that our surface water meets these standards. We also applied for treatment as a state, and Sam Maines actually helped us with our original jurisdictional statement in that application. And it can be a long, daunting process, that TAS process, to actually obtain the jurisdiction. For us, we submitted the application, and we didn't hear anything from the EPA for quite a while. And we put a little pressure on them because they have a legal requirement that they're supposed to respond within a certain number of time and tell us whether or not our application was even complete and met their criteria. So we stuck it to them, and they responded and said, okay, well, it's complete. Then another couple of years went by and we didn't hear anything. So then we started to put the pressure on a little more, and we finally got some comments back, and they said, well, you should really look at this and revise that. So we ping-ponged it back and forth a little bit. One of the significant changes we made, I'm not sure if you've seen a map of the reservation. I probably should have put one up on the screen, but the tribe has lands in Colorado and New Mexico, which are contiguous trust lands. And then in Utah, the tribe has lands that were allotted originally to individuals, and about half of those lands have reverted to tribal ownership in one way or another. EPA wasn't sure that they would offer the tribe treatment as a state over the individually owned tribal allotments over there. So we took the individual ones out and left the tribally owned ones there. A few months later, we had actually left 3 parcels in there that are half owned by the tribe and half owned by the individuals, and EPA came back and said, no, take those out too. And so they were whittling away our jurisdiction a little in Utah, but we wanted to get the jurisdiction for the bulk of the reservation, so we did that. In 2005, they approved our jurisdiction for treatment in the same manner as a state. We were the 32nd tribe, I think, in the country to get that. So then we revisited our standards that we'd adopted 5 years prior to that and started to work on updating them technically and figuring out how we were going to implement them legally. And that the bulk of that implementation is in what's called an anti-degradation implementation policy. Basically, the anti-degradation part of that means that you have certain types of tiers of water quality for different water bodies, and depending on what that tier is, you let it be degraded or you don't let it be degraded to a certain extent, in a nutshell. So we got that into the standards and went back and forth with EPA. And what they generally do with states is states will pass the standards as state law, send them to EPA for their approval, because the feds can actually promulgate what they want. If water quality goals are not being met that are inherent in the Clean Water Act, they could say, no, Mr. State Regulator, we're not going to approve that. So they'll approve state standards and condition them. They'll say, most of it, yes, but that, no. We didn't want our standards to be conditionally approved. So we worked very closely with EPA's Water Quality Standards Program in developing standards that would be EPA approved. In 2011, we got their approval for that. So we currently have EPA approved Clean Water Act standards. It was a long haul. Unique in those standards are a couple things. We have a tribal ceremonial use designation, which essentially protects different water bodies at a very high level, so that people can immerse themselves in them, drink them, and that type of stuff. That's something that a lot of tribes have done in their own unique way, and each tribe seems to have their own little tact on that, but we did that. We also have what we call outstanding tribal resource waters, and those OTRWs mimic the outstanding national resource waters, but they're tribal waters. And those are afforded the highest level of protection in the standards. Essentially no degradation. So when we look at different land use activities and things, we don't want those to be degraded in quality at all. And those are a couple springs that are of important significance to the tribe, and also one creek in Utah, Allen Canyon, which is the original home of the Allen Canyon White Mesa Utes. So that's what we've done on surface water quality standards. We are poised to undertake a triennial review in 2014. Every 3 years we have to revisit those, and next year is the year for that. So we're going to be looking at those, revising what needs to be revised, bringing them back to tribal council, getting their input, public comments, and then hopefully a revised package. Another thing we're doing with water is we have the tribal council in 2004 adopted a groundwater protection plan, and that was originally envisioned to be more of an assessment and guidance document. It doesn't have really any regulatory teeth to it. We identified the different groundwater aquifers, what they're used for in general, what pollution they are vulnerable to, and how we might mitigate that. And so what we want to do in the next year is actually take that and make it into a regulatory document. And that's going to be a little challenging. It's not going to be challenging at the tribal legal level. It's just that groundwater, like air, it doesn't obey boundaries, and so there are often influences, right on the boundaries as far as groundwater quality. But we're going to be working on that here in the next year, and hopefully at this time next year, shortly after, we'll actually have a groundwater regulatory document. On oil and gas, we're involved on a few levels. The Ute Mountain Tribe is an energy tribe. They've been fortunate to have oil and gas reserves that have been good for generating revenue for the tribe. And we have a few roles in that program. We had for a handful of years a lease compliance contract, 638 contract with the Bureau of Indian Affairs, where we would look at the leases for different oil companies on the reservation, the stipulations in those, and figure out if they were complying with them in general. As the pool of money that was allocated to our TOYUC agency of the BIA shrank and shrank and shrank, it eventually became somewhat of an unfunded mandate. So we're not really doing lease compliance for BIA there anymore. The main way that our department has a role in oil and gas is through our Brownfields Tribal Response Program. That is a EPA-funded program that deals mostly with hazardous materials. And brownfield sites are land that are contaminated that you really can't use for something else until you clean it up. So when we see oil spills and issues in the oil field, we consider those brownfield sites. And so what we're doing with the brownfields program is we respond to things, we, spills and whatnot. We interact with the companies on just so that they're aware of what the tribe expects out there. And we're also in the process of developing an oil and gas code. We talked for a few years with our Justice Department about a spills code specific to oil spills or produced water spills, and we think we're going to actually broaden the scope of it beyond just spills. We learned recently that the tribe actually has an old oil and gas code from 1987 that really hasn't been stringently implemented. And so we're trying to decide whether to enhance that or scrap it and start over. So we're working closely with our Justice Department on that. Some of the things that we're probably going to do with our oil and gas code is make a few things a little more stringent than what the federal regulations require. The Bureau of Land Management has a trust responsibility in the oil field for what's extracted from the ground. They call it all downhole issues. The BIA has a trust responsibility for surface management issues. So we work closely with those agencies, but the BLM, their spill reporting requirement is 10 barrels of oil or more, or produced water, as may be the case. That's a lot. And that can go a long ways. We had an oil spill that was actually on BLM land, that went to private land, that went to Ute land, then to Navajo land, and it was about 5 barrels of oil and then a bunch of produced water behind it, and it went a long ways, 20 miles down a creek. So we're definitely going to go less than 10 barrels on our spills code. Another way we're involved is in what they call the APD process, applications for permits to drill. And we meet with companies, BLM, BIA, in the field before a drilling operation occurs. We talk about what needs to be done on the land to reduce the impact to all the natural resources out there from the activity. We condition the APD with what the tribe sees needs to be done to protect those resources. Generally, those involve like stormwater management type of things. We have a company that we had an on-site last month, and I'm going to just tell a short story on this, and then I'm going to run out of time. But they drilled a well 2 years ago, and all of the APD paperwork went through with the understanding it was supposed to be a closed loop system. They were using that popular new well completion technique that everybody's heard about, hydraulic fracturing. Say that real quiet. And so the BLM people just went out to kind of check in on them before they did it, and they said, well, why do you have pits here? Well, those are our pits. Those are our drill pits. And they said, well, no, we said it was supposed to be closed loop. And in a closed loop system, there are no pits. You put everything into containers that you haul out of there. So they said, well, hold on, let's go back and look at our paperwork. So anyways, this company scrambled because they were on schedule to drill this well and get it completed, and they had to change course, and they were bringing in contractors. It was just chaos, but they got the job done, and they did it the way that everybody had agreed upon. So we're at this on-site with the same company last month, and we're looking at the location, and it's a very benign location. It's completely flat. You hardly ever see that. Usually you're cutting and filling and dealing with stormwater, and it was a perfectly flat, ideal situation. So we're all talking about, you know, where this is going to go and that's going to go, and they say, oh yeah, and the pits are going to go there, and I said, the pits? What? Anyways, we're all standing around, and I said, so this is going to be a closed loop job, right? Nobody said anything, and nobody said anything, and they said, well, is that what you really want? And I said, well, I think that's what we really want. And anyways, I'm glad that we got that out in the open before they started to work on it again. So my point there is just that we need to pay attention to a lot of details out there and really hold some feet to the fire, because as you're well aware, developing these natural resources like oil and gas are important for the tribe and for the world. But on the flip side, if you don't do it right, there's some severe consequences. So I'll leave it at that. I know I'm out of time, and we'll let the next guy.
Slideshow. Oil and gas potential studies. Yeah, there it is. Nope, that's agreements. Nope, not mine.
That's Tom's.
Dang it.
All right, just close
Did we
that
get
one.
If not, I have it.
Sure.
No, it's not there.
All right, let's see. No.
Nope.
This is just for review purposes.
Okay.
All right,
No, it's oil and gas. Yeah,
that's
it's,
what it is. All right, so let's use your.
potential.
Okay.
Yeah. Okay. I'm not doing it right. That's right. There we go. All right. There we go. Okay. There we go. Great. Okay. Following the trend, I am not a lawyer. I am a geologist. I hit rocks for a living. I'm Division Chief for the Division of Energy and Minerals. Our job is to provide technical assistance to tribes. This is voluntary. You don't have to use us. We're available for you. Our office is made up of all, pretty much except for my admin officer and an admin assistant, scientists and engineers. Our oil and gas group has 2 petroleum engineers, 2 geophysicists, 2 geologists associated with it. Our mineral side have 2 mining engineers, 2 geologists associated with it. And we have recently a renewable energy group, which is made up of electrical and civil engineers and a couple business people associated. They refer to us as the rock people, and we refer to them as tree huggers. I've been asked to talk about oil and gas, and you heard from the previous speaker that oil and gas is important. It's to the tribe's economy and all, and I really want to sit down and talk about some of the general things. First off, oil and gas is really important. The Department of Interior did a study on what was the economic contributions for all things non-gaming related, okay? And as you can see there, this data, this was done in June 2011. The data they used was 2010 data. As you can see, the value of resources developed on Indian lands was $3.1 billion, contributing 85% of all value generated on Indian lands. The economic impact, and I'll get to that several times, I really want to talk about economic impact this stuff has. It's $12 billion, 85%, and the number of jobs generated on Indian lands because of oil and gas and minerals is 88%. This was taken in 2010. This was a low watermark for us, okay? And I say that for the Indian people. You can take a look at all the other resources there. By far, it's 1 and 2, all right? Minerals, by the way, historically has been sand and gravel, industrial minerals. We don't have that many copper mines. We don't have any gold mines going on whatsoever. Energy is coal, oil and gas. We had uranium mines, but those aren't operating anymore. Geothermal wells. Does not include some renewable energy, but not that much, and there's a reason for that. We won't talk about it. But what's really booming, and I've tendency, we deal with the pre-lease function, okay? Pre-lease function is really important. Our office was started in 1976 because tribes did not have any geologic information whatsoever to negotiate, okay? Picture yourself as an Indian mineral owner. An oil company knocks on your door and says, I want to lease your property. You have nothing whatsoever. And when I came on board, literally, the USGS stopped mapping at Indian reservations. We did not have geologic maps. We had no information whatsoever. So part of our job was to really develop geologic information and engineering associated with it. So when a tribe goes into negotiations, and again, we assist in negotiations, they'll call us up and say, we're thinking about developing XYZ. What do you think? And we'll come back and give them a potential. We'll do, in this case, oil and gas. We'll look at acquiring geophysical data. We'll do the engineering work, and we'll come up with prospects and plays, okay? And we'll help them market it. Historically, what has happened again is tribes wait until somebody knocks on their door and says, have I got a deal for you? In the case that we've been doing right now, and again, we'll take Fort Berthold as an example, we help them become proactive in marketing that resource. They set down the terms that they were looking for. This is what we wanted. We took them to NAPE, which is the North American Prospect Expo. 25,000 people, all oil and gas people, all looking to make a deal. This is who they talked to. They went out and found people to work on their reservation. They're averaging right now between 22.5% and 25% royalty rates right now. That's being proactive. So I deal in the future, okay? I look at there and say what could be done. I'm not responsible for the regulatory side. I don't do permitting, anything like that. I'm always looking at the future and saying what's the possibility? What's the hot prospect tribe? What should she be aware of? In the case of oil and gas, these are the hot prospect areas, okay? The really good, and you can see that reservations are in a lot of good areas. The Bakken, of course, you're familiar with up at Fort Berthold. That's the biggest oil boom going on right now. But in the areas of the Ute tribes, you're looking at the Gothic Shale, the Manka Shale, being really important. I will sort of window in on those. And what's really opening it up, quite honestly, is that we've known about these resources for years. The problem is technology. Technology has evolved, where now we're doing horizontal drilling. Horizontal drilling, by the way, has been around since the 70s, 60s. Southern Utes been doing horizontal drilling since 80s on their coal bed methane. Fracturing has been around since, hydrofracturing has been around since the 50s. It's constantly evolving, and it has evolved right now, and it was only until the last several years, about 5 years ago, they put the two together. And that's really opened up all these different basins. So, what's happened to Indian royalties? As you can see right there, we're currently, this is the latest data available. I should get rid of the estimate. I did this the other night. That's what happens when you do things late at night. We're at $700 million. $700 million. 700 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 And you can see the 2010 was at about 400 million. So we've really popped up. We're currently, and if we do the math on the reserve calculations there, projected drilling and all that, we think in the next 2 years we're going to hit $1 billion in resources, revenue to the tribes. We're pretty happy about that. As I say, we assist in negotiations. This is the gross value, Indian versus federal. We beat them by easy 5%, real easy. Okay, and you can see that we're on the incline. What that is, all I did was simply take how much royalty was generated, what was the value of the resource, divided it, there you go. That's the percentage. So we're basically getting about 16, and at this case, 16, this year basically we're about 16.8% of all the value of that resource goes to the tribe. And you can compare that to the federal lands, which is right around, less than, right around 11.5%. So we think we do a real good job. This next year we think we're going to be a better job. We're hoping to top out right around 20%. Okay, and bear in mind that number represents past productions, not the year, that year. Some reservations, as I said, for Berthel, 22.5%, 25%. Other reservations, not so much, and it just depends on the prospect and play that you're talking about. But we're real happy about how that's taken off on us. Okay, as a geologist, I get to wave my arms and lie to you, so just prepare to be lied to, okay? This is the location of the Southern Ute and Ute Mountain Reservation. I just there's no, by the way, order of priority. I just picked them as they came through. What we're looking at is the Paradox Basin. The Southern Ute is located in actually two basins, the Paradox Basin and the San Juan Basin. San Juan Basin, historically, what you're looking at is a lot of fruitland coal formation, methane gas, coal bed methane gas. We assisted the tribe back in 1988 in producing a guidebook. It was through the Rocky Mountain Geological Association, RMAG, and in 2088, we assisted them in processing, I think, 400 permits so that they could kickstart their drilling process. The reason for that is that there was a tax credit for coal bed methane gas that was running out. Had to be done. Had to get the wells in the ground. Once they were done, they got the tax credit, and it was becoming very economical and really did help that tribe out. The Ute Mountain, we did a guidebook for those guys back in, I want to say 1999. Again, it's the Paradox Basin. It was done through the Four Corners Society. But you take a look at it, here's all the basins. This is sort of what we look at when we get something like this. So if a tribe comes to us and says, we're interested in knowing what your resource, what do we have? And a lot of them do come to us and say, what do we have? What's our potential? We look at it and we see what's going off reservation and what's trending on in, okay? And in this case, you want to take a look at the little green dots right there. And those actually, and us looking at are old algae piles, okay? And we're looking at where they mounds encased, and they're encased by shales, and they produce oil, okay? It's kind of a neat thing, okay? And if you take a little closer look at the Ute Mountain Ute Reservation, you can see the northern area, and what we do is we do a lot of processing, 3D, in this case, 2D and 3D processing of seismic, and I'm going to draw your attention to the Roadrunner 3D prospect area there. We're able to come up with prospects like that, okay? Drilling oil is a high risk, high rewards operation. If we can do anything to take some of the risk out of that, we get a higher royalty rate. We being the tribes, okay? This is what's being marketed currently right now out there as far as being a possibility. And it's the bad news is that this is not a direct indicator of oil and gas, just talking about the possibility, okay? So in that case, we have to lie to our contemporaries, okay? So one of the other things we're looking at too, and this goes to what we talked about with the shales, with the fracking and everything else. This is what we're looking at. The Gothic Shale actually is one of the projects, big things that are going through, and I know Southern Ute is looking at it on the northwestern part of the res. How it's going through. It's more oil. We think it's more gas prone there and more oil prone here. What we're really keeping an eye on is Bill Barrett Corporation is drilling a hole right now, and we're tracking it very, very closely. And once we know the results of that hole, we can then go talk and probably change this whole damn thing again to something else, all righty, because we'll have actually, actual data, whereas opposed we're a pretty map, okay? And that's the beauty of it. It's a pretty map. It looks like we did a whole bunch. We really didn't. We stuck stuff together. And we're kind of looking at, when basically this is based on our geochemists looking at it and coming up with an idea. So Southern Ute, again, the seismic that they have looking over the existing oil. Gas right now is, and he'll probably tell you, is in the dumpster. We have lots and lots of natural gas. Basically, the eastern fields are beating us to the march. They're producing a lot of gas in Pennsylvania, New York, and we're not be able to meet that market. Okay, it went from a high of what, $5 a MCF, somewhere around there. Now it's about $3, $3.50, and so it's really not an economical thing. So the tribe is sort of looking at this and saying, hey, we're sort of taking a break on it. But they have a tremendous amount of resources there, and this is what's called a resource play. We know the fruitland formation's there. It's a matter of drilling and developing it, okay? And they're not looking for our help, by the way. So when you look at the southern Ute Mountain Ute, basically Gothic shale is the big thing that's coming down at them that we think we're keeping an eye on, that we should be aware of, okay? And if it hits, it's going to hit big. And that's going to really impact the tribe. And so we talk with the tribes about what they should be aware of. Also, you saw the thing where the economic impact. We want to look at how we turn over dollars on that reservation, okay? So we want those dollars to stay on that reservation as long as they can. The longer they can, the more benefit it's going to have to that tribe, okay? The saying that we tell the tribe is, they may or may not find oil, but those guys are going to have to eat, and they are going to have to sleep, and they are going to wear clothes. So how about you guys sell those things? That's something that the tribes can take advantage of. Southern Ute really don't need our help. They've got a tremendous technical group out there that puts us to shame. They are some really great guys. Bob Zaradnik, I've known him for years, head of the whole thing there. He knows what's going on. He doesn't need our help on doing any of this stuff, but we're sort of keeping track of it and just sort of a cursory thing, professional thing. Now we're going to talk about the UNO. UNO Reservation is going through a boom right now. Don't have to tell, if anybody from the Ute Mountain Ute, don't have to tell you that. They are going through a big boom. Oil is really up there. By the way, all oil is not created equal. This one has a high paraffin content, which if you take a look at and say, well, God, it's got a lot of wax in it, that's not good. Actually, before the price of oil got up to as high as it did, the paraffin was worth more than the oil. So the paraffin used for developing perfumes and so on. I'm going to zip on that. Northern Ute, basically the biggest problem we're having right now, or the tribe is having, is not something we're a part of, but just processing permits. They went from like 50 permits per year to 600 permits a year, and could do 1,000 permits a year if we could. And that's the BI services, just getting the rights away and getting things through as quick as it can. Kind of excited about it. They will have horizontal drilling. They're going to see decrease in gas just because gas is so low and nobody will look at gas. So I think that's it. So good.
Good afternoon. My name's Sam Maines. I'm an attorney with Maines, Bradford, Shipson, Sheftel. We serve as general counsel to the Southern Ute Indian Tribe. I've had the good fortune of most of my career working on Southern Ute Indian Tribe projects. And so I'm pleased to be here today and I'm pleased to have the opportunity to talk about natural resource development on the Southern Ute Indian Reservation. It's not a difficult subject to talk about, as has been mentioned by other speakers. There is an abundance of natural resources on the Southern Ute Indian Reservation, and the tribe has had many successes in the development of its natural resources. And by successes, I mean not only economically successful, but also the tribe has succeeded in preserving and protecting those natural resources for future generations. So here's a couple of pictures of the reservation, one in fall, one in winter. So the topics I want to talk about today include some of the legal highlights in the tribe's development of its natural resources. And I don't want to spend too much time on that, though. With only 12 or 15 minutes, there's really not much time to get into too much depth. So my discussion of those highlights will be sort of an overview. Then at the end, I would like to talk about what have been some of the keys to the tribe's successes in the development of its resources. And then finally, at the end, I'd like to share what I see as some of the key drivers for future development. We haven't talked too much about that so far, and I think that's an important topic to consider. Some knowledge of early history is important. You've seen this before. This slide depicts the evolution of the reservation and its reduction in size over time and the creation of separate reservations for the 3 Ute tribes. Other early history includes the Indian Reorganization Act of 1934, the tribe's adoption of its constitution in 1936, and importantly, in 1938, as promised in the Indian Reorganization Act, that's where Congress said if tribes will reorganize themselves, adopt a constitution, then any surplus lands, that is lands that were not homesteaded or were not allotted, those surplus lands would be restored to tribal ownership. And so in 1938, the tribe, there was restored to tribal ownership, not only surface estates, but also the coal estate that had been reserved to the United States during homesteading. Some of the highlights in the tribe's energy development have included the restoration of surplus lands, which I just mentioned. Also in 1976, there was a realization by the tribal government that the Bureau of Indian Affairs wasn't doing all it could to maximize the benefits of energy development to the tribe. And so the government imposed a moratorium on additional leasing. Leonard Birch, the chairman at the time, the young chairman at the time, is generally credited with imposing the moratorium, and it wasn't a politically popular move for him to take. But the tribal government supported it. The moratorium was imposed. At the same time, the tribe set about gathering information about its energy resources, collecting even, for example, the actual leases. Before that time, the tribe didn't have access to the leases that had been in place for years, had no way of knowing whether operators were complying with their lease obligations. And so for several years, there was work done to gather all of that information. The tribe's severance tax ordinance was adopted in 1982. That was soon after the Marion decision in the Supreme Court, where the court held that tribes have the power to tax the production of tribal minerals. And so soon after that, the tribe adopted its severance tax ordinance. And that's a real highlight, because economically, that's been very beneficial to the tribe. The tribe entered into a memorandum of understanding with the Minerals Management Service, under which the tribe can audit operator compliance with its lease obligations, and most importantly, its royalty payment obligations. And through that program, over the years, the tribe has recovered millions of dollars. It's been a very beneficial program for the tribe. There have been numerous intergovernmental agreements between the tribe and the state and with federal agencies. My colleague, Mr. Mills, will be talking more about those later on. Those have been critical to the tribe's success in the area of mineral development. There are agreements with the state and with BLM for determining well spacing and well density on the reservation in a cooperative manner. The creation of Red Willow Production Company in 1992 is a highlight. That's the tribe's on-reservation oil and gas exploration and production company. The operation of Red Willow has been so successful that the tribe has expanded its operations off-reservation, as was mentioned this morning, to include operations as far north as Canada and as far south as the Gulf of Mexico. 1994, the tribe formed a joint venture known as Red Cedar Gathering Company. That company owns and operates gas gathering pipelines and gas processing plants on the reservation, and that's been a very successful endeavor, one in which the tribe's ownership has gradually increased to the point where now the tribe is the majority owner, 51% majority owner. Finally, another highlight in the tribe's development of its mineral estate is the taxation compact between the tribe, the Plata County, and the state of Colorado. Under this compact, all of the tribe's real property interests on the reservation are recognized as tax exempt. For those interests that are owned in fee status, the tribe makes a payment in lieu of taxes, which amounts to about 1/3 of what the taxes would be but for the tribe's ownership. And it's really a win-win arrangement between the tribe and the county. The tribe's 1/3 payment is for the non-public school share of the property tax. The other 2/3 share is the school tax, and any shortfall in the school tax is made up for through the state's school funding mechanism. So it's a win-win. The county is made whole, the tribe's sovereignty is recognized, and the tribe makes a voluntary payment in lieu of taxes. So that's a very beneficial agreement for the tribe. And one other highlight I think deserves mention is the tribe's coal bed methane case. That case was where the tribe claimed ownership to the coal bed methane gas that was being extracted from its reserve coal estate that had been restored to tribal ownership. And the law school was a big help in that case. Several of the law school professors, I think Professor Collins, Professor Wilkinson, and Professor Getches, all provided assistance in reviewing briefs, and also I think the law school hosted at least 2 mock oral arguments, one before the 10th Circuit heard the case, and one again before the U.S. Supreme Court heard the case. And that case isn't a highlight in the development of the tribe's energy resource because the Supreme Court ultimately ruled in the tribe's favor. The court ruled against the tribe and held that the coal bed methane belonged to the fee oil and gas owners. It's a highlight because just before the U.S. Supreme Court decided the case, the tribe entered into a settlement agreement with Amoco, under which basically the tribe became a partner with Amoco in the production of the coal bed methane from the disputed wells. And that's been hugely economically beneficial to the tribe. So the tribe has taken steps not only to develop its natural resources, but it's taken steps to ensure the protection and preservation of its natural resources. There are many ways that it's done that. One way is in how it's regulated the disposal of waste that's produced as part of the mining process. Early on, in order to avoid potential pollution of drinking water wells, the tribe insisted that produced water, that's the salty, briny water that's produced as part of coal bed methane development, the tribe insisted that that water be injected in deep underground wells as the safest, most environmentally protective way to dispose of that water. More recently, the tribe, in an effort to minimize surface impacts, has conditioned its consent to increased well density on the co-location of wells on a single well pad and the use of directional drilling in order to minimize surface impacts. The tribe has a long-standing and active range management program under which the range is managed for long-term sustainability. The tribe has had a gravel business for quite a few years. That business was successful on reservation. It expanded off reservation, and a few years ago, the tribe sold that business, so it's no longer in the gravel business. Oh, one other highlight that was mentioned this morning and that I would like to mention as well is Public Law 98-290. That's the 1984 Act, which confirmed the exterior boundaries of the reservation, and Professor Collins deserves some credit for that act, assisting in drafting and making statements that are in the legislative record in support of that act, and that's been a hugely important act that's specific to the Southern Ute Indian Reservation. And really, there's been many times over the years we've felt great gratitude that Professor Collins and others who worked on that back in 1984 had the foresight, and the tribal leaders, of course, had the foresight to confirm the exterior boundaries and prevent the loss of tribal land through disestablishment. Other tribal natural resources include the tribe's air resources and the tribe's water. Both the tribe's air program and the tribe's water quality program are sort of in the process of trying to transition from just monitoring programs to actual regulatory programs under which the tribe sets standards, issues permits, monitors compliance, and enforces compliance. The air program is ahead of the water program in that regard. The reservation is a clean air area. It's currently in attainment for all of the national ambient air quality standards. Historically, EPA has regulated air pollution on the reservation, issuing permits, but that's changed over the last 10 or 15 years. The tribe and the state entered into an intergovernmental agreement concerning air pollution control on the reservation in 1999, and under that agreement, the tribe and the state basically share regulatory control over air pollution control on the reservation. There's a joint commission that's composed of 6 members. 3 are appointed by the governor, 3 are appointed by the tribal council, and that joint commission decides on which air programs will apply on the reservation and adopts the regulations for those programs. The first program that was approved by the joint commission was the operating permits program, also known as the Major Source Program. There are about 44 or 45 major sources of air pollution on the reservation, and the tribe is in the process of permitting those sources. I won't talk too much about water resources. The tribe is in the process of revising its water quality standards now. Wildlife, I won't spend too much time on either, because I believe Mr. Mills will be talking some about the Bruneau MOU between the tribe and the state. The tribe has both on-reservation wildlife resources as well as the off-reservation Bruneau treaty hunting area. The tribe has a professional staff of biologists in its wildlife division, and I've listed some of the highlights of its on-reservation wildlife management program on this slide. Here's a slide showing the Bruneau area and a couple of the highlights associated with the Bruneau area, including the 1972 consent decree under which the tribe agreed not to exercise its Bruneau agreement rights. And then in 2008, the tribe changed course and said, you know, we want to exercise those rights, and entered into a new MOU with the state. So what have been some of the keys to the tribe's success in natural resource development? What are some of the lessons to be learned from the Southern Ute experience? Well, one is that teamwork is important. In almost all of the tribe's activities and major programs and major decisions, there's a team of people who are working to make recommendations to the tribal council, and that team approach has proven to be very successful for the tribe. Another lesson to be learned is that it's important to develop internal expertise. The tribe has worked hard to hire experienced and qualified people throughout its organization, and that knowledge is being internally developed and internally passed on so that the tribe can continue to fulfill or achieve its objectives. And another important lesson is intergovernmental cooperation, and that was mentioned this morning as well. The tribe has many intergovernmental agreements, and the tribe has found time and again that intergovernmental cooperation is a much quicker and much less costly way to achieve its objectives than fighting with its neighbors and litigating issues. So, what are some of the key drivers, or what will be some of the key drivers to future development on the reservation? I've listed some here. I want to talk briefly about two. One is the relationship between the tribe and the federal government, and in particular the Bureau of Indian Affairs. That relationship, I'm not sure what it is like for the other Ute tribes. I've heard that at Northern Ute it's much better, but at Southern Ute it's very much like being married to someone that you don't like, and that there's no easy way to get a divorce. The agency has, instead of facilitating the processing of realty transactions, energy transactions, has really become quite an impediment to the timely processing of those transactions. And I'm glad to hear Steve is working on it, because it's important. We need help at Southern Ute in that relationship. But I say there's no easy way to get a divorce, but I think there are ways to create space between the tribe and the federal government. The traditional ways have included 638 contracting and self-governance compacting, and the tribe has taken full advantage of 638 contracting, has many 638 contracts. But I think Congress has established a model for tribes who want a different relationship with the federal government. And that model is reflected in a couple of fairly recent acts, the 2005 Energy Policy Act and the more recent Hearth Act. Under those those acts, tribes are able to avoid the need for federal approval of all of its transactions if they'll adopt their own regulations and have those regulations approved by the Secretary of Interior. Importantly, though, and this is what makes it not easy, is that there has to be included in those regulations a process for evaluating the impacts of the tribe's actions, and it has to include a public process, and it has to include a process under which the Secretary can revoke approval of those regulations in the event it's shown that the tribe isn't following its own regulations. So I think that's a way that the relationship can change. The other key driver to future development is air pollution control, and you've seen that on the UNO reservation, where the area, although it's a rural area, is either in non-attainment or close to non-attainment for ozone. And once an area moves into non-attainment, those limitations and constraints on development ramp up. And that's going to prevent a lot of development in the future. So what's the tribe's greatest natural resource? It's its members. Councilwoman Eagle mentioned it this morning, that despite some of the tragic history, that the tribal members' strength and courage has sustained them through many hard times. And the Southern Ute Indian tribal members have shown themselves to be resilient, visionary, and as a tribe, they have embraced self-determination. And so the Southern Ute members are really the tribe's greatest natural resource. In conclusion, I'd like to say that being involved in natural resource development in Indian country at this time is exciting. The times are changing, and there's more of an opportunity now than ever for collaboration and cooperation, for students to get involved in this area of law, and that's all I have. Thank you very much.
My name is Tom Fredericks. I'm at the age now where I don't walk too well and I don't see too well. So I'm just going to sit here and talk here. And I'm not going to use my my PowerPoint. Hopefully you've received a copy of it. But I just wanted to talk a little bit about development and the resources of the Ute Reservation, or the UNO Reservation, the Ute Indian Tribe of Utah. Charles and Chairwoman Kutch talked about the history, and I wanted to add a little bit about the history because it's one of the, it's you know, I've been around quite a while, and it's the most devastating history of a tribe that I can remember, because when you go to the reservation, you have national forest land, you have BOR land, you have BLM land, you have state land, you have a state wildlife preserve, and then you have the Indian and allotted land. And all that has created a nightmare for the community. Now, we can't, you know, I can't find any authority for half the stuff that's happened out there. You know, and it seems like, well, it started out fairly well when they got the reservation in 1861 and 1862. Then they passed the Reclamation Act in 1902. So they and they allotted the reservation in 1905. So the allotment process on the Uncompahgre did not go so well. I think Brigham Young, when he left the Uinta Valley, said that it wasn't fit for a jackrabbit to live there. So nobody on the Uncompahgre could even survive on 160 acres. So that when they allotted it, there was only 22 allotments that were given, and those were along streams that ran through the area. And I don't think any of them are even, or very few are in existence today. But the other reservation, the Uinta Valley, the allotment process took place. They allotted the lands, and then they opened it up for homesteading. And over 1 million acres of land was homesteaded. So and it was all the best land that were along the rivers and along the heart of the reservation. And that has created jurisdictional problems for us. But also then in 1906, after the allotment, we had some money. So the United States, or the Bureau of Indian Affairs, the Department of Interior, decided we should have an irrigation project. And we'll get into that later on, but they took that money and they created an irrigation project for about 79,000 acres of land, which was a nice size irrigation project. But the problem was, there was no storage. The water was there at the wrong times of the year. And so it's not been as successful as we would have liked. But the United States, having done created the irrigation project, decided, well, we better protect the Indians' water. So we're going to create a national forest. And they created the national forest in the northern mountains of the reservation so that they could protect the water. And they took a lot of the land from the reservation without compensating them for years before they finally did. But these are the kinds of things that happened out there. Sam mentioned that when they opened up the Southern Ute Reservation and they homesteaded, and what they didn't homestead, they returned back to the reservation or to the tribe. Well, at Uncompahgre, they didn't do that. The 22 allotments were granted. There was no homesteading on there, but the United States took all the land and put it into United States ownership. So they didn't return it to the tribe, and it wasn't until Charlie pointed out the Hill Creek extension, which was over 1 million acres, it was in, I think, in 1948. So this reservation has had a lot of activity, but the one thing that that Brigham Young and some of the other people that inhabited that area with the Utes didn't recognize is that there was a lot of minerals on the reservation. And that's been the saving grace for the tribe. They're dependent heavily on the development of oil and gas for their existence. So with that, then I would like to talk about basically developing resources on the reservation. I told you a little bit about the water. Dr. Mishkina, who's our water engineer, will go into that in detail tomorrow. So I don't want to talk too much about that, but I want to talk about oil and gas and the strategy for developing it. And at the turn of the century, the Ute tribe was tired of being a passive lessor. They had so they wanted to become more proactive in the development of their resources. So they created an energy and minerals department that would help regulate the oil and gas development, and they created a tax after Marion to tax the minerals. They developed a tax agreement with the state on mineral development, and it was they set the stage for development that way. And then the IMDA, they utilized the IMDA to develop to enter into agreements with the major producers that are producing out on the reservation. And I say that because the IMDA is a very important statute, and I just wrote an article in the Federal Lawyer on the cotton case and trying to get Interior to regulate tax agreements. And that's important because in our development of Indian minerals, we look at trying to, what I call, develop a level playing field. And I talk to the operators a lot, and the operators are always pushing us to try to get permits. Steve mentioned permitting. Well, permits are the right to drill a well, a permit to drill the well. And in that, you have to get a right-of-way, and they start out where it involves the BIA, and then it involves energy and minerals, and then it goes to BLM after all that. And the big kicker in this, or the holdback in the process, is the environmental. And the environmental laws require public participation, and with that requires time. And so when we get a permit going, it requires probably, I would say, it should require 90 days. At Ute, we're lucky if we can get it done in 6 months, and it's maybe a year to get a permit. And as Steve pointed out, we've gone from maybe 50 permits a year to hundreds of permits. And the importance of that, you know, the reason I bring that up is because if you have a permit and the producers are dependent upon getting those permits. And if they contract for a rig and bring it onto the reservation, they have to pay for that rig. And so they're going to make sure that they have the permits to keep that rig operating. And as was pointed out, this is a very important time because for every well that's drilled, the Ute tribe in 5 years will get $4 million. And so I'm told by operators, Tom, we can't get permits. We'd like to bring 4 rigs out there, but we're only going to stay with our 2 because we're not assured that we can get the permits. So you can see that, you know, when the drilling is hot, you know, they want to drill, but the permitting process. And so when I looked at that, I tried to say, well, what's the problems? Why are we having these problems? Well, and the producers would rather go to fee land than trust land or federal land because of these problems. So the first thing I looked at is that why is BLM involved in permitting? I looked at their statute in FLIPMA. It says that BLM shall manage the public lands of the United States. And in that definition of public lands, it says that public lands do not include Indian lands. So I challenged them and said, well, why are we having BLM? BLM is an agency that is charged with managing public lands. They have a whole different management style. They're not interested in making dollars. They're interested in protecting the lands for the public. Whereas the Indian Bureau and the trust responsibility and the IMDA require that we maximize the return for the Indians in the development of their minerals. So there's a conflict between the management of BLM and the management of lands under the BIA. So we have taken them on, and why do we try to get the BLM out of it? Because they now want to do fracking, regulate fracking. And as somebody pointed out earlier, fracking is a process that has enabled a lot of development in the shale rock of the United States, along with horizontal drilling. And an article, a study just came out where fracking will cost us $130,000 a well. So that cost then is taken out of our minerals. It's not good. So that's why we think that we shouldn't be under the BLM's fracking regs. We should be under BIA jurisdiction. We challenged BLM, and they said, well, in our manual, it says the Secretary can regulate all lands of the United States. And so they're relying on a manual to override a statute of Congress where they specifically are told they do not have authority over Indian lands. And I wrote an article on it. I think it's in the journal, or Energy Journal out of Tulsa, to try to get them to change their mind. The other thing that's a big problem in Indian country, now talk about leveling the playing field, is the dual taxation. The dual taxation, as somebody pointed out, in cotton, the state was allowed to tax the operators' interest on the reservation development. And the Indians were allowed to tax under Marion, the Supreme Court case in Marion. So now we have dual taxation. So that's the problem. At Ute, we were able to develop, but we have a 10% tribal tax, and we have about a 5.5% state tax. So they're taxed more at Ute, but it hasn't been a problem. At Fort Berthold, it was a big problem. The tribe had I don't recall, I think there's 11.5% tax that the state of North Dakota has, and the tribe tried to tax at 10%. So they were going to be taxed at 21.5%, and the companies just wouldn't develop on the tribal lands. So there was a donut hole in the Bakken at Fort Berthold. And so that's why this is important. The cotton, the revisiting of cotton is important. So I looked at the cotton decision, and we're looking at it to see if there's any way that we can bring some relief to this dual taxation. And we come up with the idea of trying to get the Secretary to regulate state taxation on Indian lands. And our rationale for that is that under the IMDA, the United States is charged with getting the maximum return for the Indians. That's one of the purposes of the IMDA. And I'm proud to say that when I was Assistant Secretary, we had an agreement come in that was between the Northern Cheyenne and Atlantic Richfield. And it was a joint venture. And I don't know if you guys know, but under federal law, you can only encumber or alienate Indian property as authorized by Congress. And so my lawyer, when I was Assistant Secretary, I had just been the solicitor, so all my solicitors were telling me, Tom, you can't sign that agreement. But I had the White House calling me, I had Melcher calling me from Montana, saying, what are you doing to these Indians? So I said, well, I'm going to sign that agreement, Senator, but you're going to enact a law that allows us to do that. And I'm going to negotiate from Atlantic Richfield an indemnification for myself if I sign that. And I did, I signed it, and then they agreed to do the IMDA. So that's how the IMDA got agreement to do, was as a result of a Northern Cheyenne agreement in Atlantic Richfield, where they joint ventured on about 20 wells, I think. But that's, so that, getting back then to cotton. In cotton, the court took a lot of liberty by saying nowhere in the Indian Mineral Leasing Act did Congress say that they had to maximize the return. to the Indians in the development of oil and gas. So they didn't, so that's what as a result of that, I think the answer that, or the lesson in that, is that Indians should be developing under the IMDA and not the IMLA. And I noticed that a lot of leases of allotted lands are under the IMLA, or the Allotted Leasing Act. And I don't know if they have to maximize the returns. I haven't looked at the allotments part, but under the tribal leasing, they do not. So it's important that we change and try to develop where we can maximize the return to the Indians. And so with that, then, we are looking at trying to get the Secretary to regulate tax agreements. And the tax agreements would be regulated so that the states can tax, but they can only tax to recover the services that they're providing. And I just had I think Patrice asked me to write an article, so I put an article in the, what's it called, the Federal Lawyer, on this cotton dichotomy here. And hopefully we'll get some traction at Interior to see if they'll regulate. We want them to do promulgate a rule and say that no state can tax without the Secretary's approval. Now, whether we get that or not, I think it's a long haul, but it's a start. And hopefully we may be able to get Congress to pass a law where we're not taking away the state's right to tax. We're just saying that the state can tax only to the limit of the services they provide. They can recoup their services. So those are all the kind of leveling the playing field. The other important thing is in NEPA, in the NEPA law, and that's why I talked about the public lands. The public lands, in NEPA, they treat Indian lands as though they're public lands. And that's why I didn't want to read I'm almost out of time, so. But they treat public land, under NEPA, they treat all public lands, Indian lands as public lands, and they allow all the United States to comment on Indian development. At Fort Berthold, we were doing a refinery. It took us 6 years to get a permit, a discharge permit. No, it was longer than that. I think it was, maybe it was 6 years. And in the state process, it takes a year. So that's the problem, and the problem is that all these well-funded environmental groups in Washington, D.C., and New York, and California, that's all they do is review things. And there's one lady, that's all she does is review EISs, and then they comment on them. So under NEPA, the lead agency has to respond to all the comments. So if you have 1,000 comments, you have to respond to 1,000 comments. So what we're trying to do is we're trying to get Indian land out of this box we're in as public lands, and we're trying to say that Indian lands should be treated under NEPA separately, and that only the Indian community and the surrounding non-Indian community can comment on actions, proposed action, federal actions. Now we've got EPA doing some of that on some of their stuff. They're allowing publication on the reservation and comments from around the reservation, and not the whole country. So I wanted to say a little bit about how much time do I have left? I can't see when you hold up that card. I'm blind, so you get done. I just wanted to conclude then. Well, I wanted to talk a little bit about development. The development